First and foremost, let me just state that our grand jury room that we're currently in is under construction, so I apologize for any inconvenience that may cause. Today's a day where we remember individuals in CPS. It's not a day where we beat our chests. It's a solemn day. On January 4th, 2024, Sullivan County Court Judge Jim Farrell accepted for public filing a 100-page grand jury report pursuant to Criminal Procedure Law 190.85, subsection 1, subsection C, recommending legislative, executive, or administrative action be taken in the public interest. Specifically, this grand jury found that the legal representation provided to the Sullivan County Department of Social Services and Child Protective Services falls short of the high quality work those professionals deserve and that best serve Sullivan County. The impetus of this investigation was the untimely and tragic death of a 16-month-old child who, along with her family, was under the supervision of CPS. Based on the facts learned during the investigation into her death, as well as the significant rate of positive toxicology babies born in Sullivan County, it was incumbent upon law enforcement and the district attorney's office to determine the basis for the decision to deny the request for removal and whether this tragedy could have been prevented. Ultimately, the grand jury concluded that this death was preventable. This investigation spanned over 4 months, during which the grand jurors heard from over 20 witnesses, including current and former CPS officials, and considered over 84 exhibits consisting of hundreds of pages of documents, including case files, notes, statistics, emails, manuals, photographs, and video evidence. The grand jury specifically investigated 18 cases under CPS supervision. These cases included allegations of pervasive substance abuse by parents, children born with positive toxicologies, ongoing domestic violence in the presence of children, domestic violence against the mother and sexual abuse against the children, cruel and unusual punishments, intellectually unfit parents that were dropping their children on the floor and did not know when to feed them, infants born 6 weeks premature, and within the 10 days the mother had custody, the infant was found struggling to breathe, cold to the touch, rigid, lethargic, multiple injuries diagnosed by medical personnel, including fractures to the skull, rapes, femur, lacerations to the liver, retinal hemorrhage, and a brain bleed, amongst many others. As a result of this comprehensive investigation, the grand jury found that the Office of the County Attorney, as DSS's and CPS's legal branch, violated its ethical obligations to competently represent the department's needs, specifically as relevant to the timely filing of petitions for services, for abuse, for neglect, and for the termination of parental rights. Outright refusing to file same for cases that warrant such. Its understanding and implementation of the legal theory of derivative neglect. Its conduct related to positive toxicology babies. It's refusing to file petitions if it believed an Article 10 neglect petition was to be filed by a family resource. By refusing to present any evidence at fair hearings, as well as other conduct unbecoming of the Office of the County Attorney, including sexist treatment of CPS officials, violating its fiduciary duty to the county by exposing the county to a potential loss of $434,000 for its failure to address deficient federal audit standards, among others. Additionally, the grand jury concluded that there is a drastic decline in the filings of abuse and neglect petitions since the county attorney's office usurped that responsibility from DFS Legal. Nearly 50% decline in filings seeking to terminate parental rights, which thereby prevented children from being freed for adoption. The Office of the County Attorney repeatedly failed to file correct petitions. The Office of the County Attorney failed to subpoena required medical records when requested. The Office of the County Attorney request to alter official notes documented by CPS's conduct system is a legal and ethical breach of its duties. The Office of the County Attorney repeatedly failed to communicate with its client, DSS and CPS, and the Office of the County Attorney repeatedly failed to present any evidence at fair hearings. In its final analysis, the grand jury recommended the following legislative, executive, or administrative action to be taken in the public interest. 1, that the county attorney's office should be divested of all responsibility of CPS's legal representation, and DFS's legal department should be reinstituted as it previously existed. 2, there should be an annual reporting process created for CPS as to the quality of their legal representation the workers understand they received in a given year. 3, there should be a complete rethinking of the use of motels to house vulnerable populations in Sullivan County. 4, Sullivan County should create its own drug treatment facility. 5, CPS should obtain the ability to test their clients in-house. And 6, the Sullivan County Legislature should create its own legislative subcommittee to work to facilitate local Sullivan County hospitals adopting the double doctor override for maternal refusal to accept drug testing at delivery and refusing drug testing of an infant experiencing withdrawals. This report is a call to action that calls out for new, bold ideas, vision, and leadership. In short, the grand jury concluded that under the office of the county attorney, their leadership, children all across Sullivan County are exposed to unnecessary risk of harm owing to repeated breaches of its ethical duties to competently represent DSS and CPS. This is a bipartisan and impartial report. It was 23 citizens of Sullivan County that comprised the grand jury that investigated these findings, heard from these witnesses, and found, by preponderance of the evidence from a credible testimony and evidence, that these reports are necessary, which was then confirmed by Sullivan County Judge Jim Farrell releasing the report. CPS and DSS worked tirelessly in good faith to protect Sullivan County, to protect the children of Sullivan County, and I applaud them for their efforts. Voluntary safety plans was heavily relied on by the Office of the County Attorney. These are voluntary plans that are not protected through court order, and they should not be so heavily relied on. I question why the Office of the County Attorney needed to establish a new position to help with the family court caseload, and these are the results that they delivered. This report does not identify any individual by name, nor is it critical of any identifiable person. However, the former county attorney, Michael McGuire, has taken it upon himself to criticize both the grand jury's findings and the procedures of the grand jury investigation. It is important to note, however, that Mike McGuire was afforded the opportunity to testify before this grand jury and present evidence. However, he chose not to do so. It is equally important to remember that under his leadership, we lost a child, which is a tragic and unspeakable death. Reports were made to remove this child from the household of the family, and those requests to remove were denied. This grand jury report took a lot of work from many people, and I specifically want to thank the officials at DSS and CPS for coming forward and participating in this investigation. I want to thank the grand jurors that undertook this investigation for the long hours in which they dutifully worked. I'd like to thank my assistant, Danielle Blackaby, for tireless effort in helping with this report, as well as my chief ADA, Michael Puma, as well as all of the Sullivan County District Attorney's Office. In addition, I would like to thank the Village of Liberty Police Department and its chief, Steve DeGata, for assisting in this investigation. Ladies and gentlemen, thank you. I'll turn the podium now over to Chairwoman Nadia Raj. God bless our law enforcement, and God bless America.
Buddy. The Metrovert.
Yes. These are some of my fellow legislators that were able to come here today. Good afternoon. In light of this report, this horrific report with all these horrific details and the recommendations of the grand jury, the legislature will do whatever it can to support the DA and the Commissioner of Social Services to ensure that these recommendations are addressed and corrected. I would like to thank the grand jury for dedicating their time and listening to all of these horrific events while they were viewing this case, and for their courage in issuing this report. And again, we will do whatever it takes in providing the necessary resources in supporting the DA and the Commissioner to preventing this from happening again. Thank you very much. You guys want to say something?
No, sure.
Thank you.
Covered it.